3 weeks ago, you asked your HOA board for the budget and the reserve study. In writing, exactly like you were told to. Nothing came back. Not a denial, not an extension notice. Just silence. Somewhere in that silence, a clock might already be running against your board. Or there might be no clock running at all, depending entirely on which state you live in. I'm Des Whitaker. This is Homeowner Rights Explained. Today, exactly how long your HOA has to answer, state by state, what it costs them to blow the deadline, and the one thing that actually starts the clock in the first place. Start with what's true everywhere. There is no federal law that puts a deadline on this. Every number you're about to hear comes from state statute, or from your own CC&Rs, where the statute stays silent. So the first move is the same no matter where you live. Put the request in writing and name the specific records you want. The budget, the reserve study, the meeting minutes, not a vague ask for everything. In 2 states specifically, Florida and Colorado, how you send it changes what you're owed, not just whether you get an answer. Email starts the clock. Certified mail, return receipt requested, starts the clock and, if the board is late, triggers the penalty math. Skip the certified mail in either of those 2 states, and a slow board may still owe you the records. It won't owe you the money. 2 more things that change what actually lands in your inbox. Almost every state exempts the same handful of categories: attorney-client and litigation files, personnel records, other owners' individual account files, and executive session minutes. If your request comes back denied entirely, check whether the board is citing one of those buckets or just stonewalling. Those are different problems with different fixes. Some states also let the board ask why you want the records before releasing them. Florida and Colorado specifically cannot demand a reason, full stop. And one myth worth killing here: HOA records are not government records. No state's Freedom of Information law reaches them because your association isn't a government body. The only piece of this that's genuinely public is the recorded declaration itself, sitting in your county's land records. So once you know your state's number, what do you actually send? A written request has to do 2 things well. Name the statute your state uses and give the board a deadline in writing, not just a verbal one. I've put the one I'd send in the kit linked below. Now, here's what actually happens, state by state, when a board ignores it. Here's the actual spread, and California is the one to get right first. It's explained. Confirmed against the state's own law, not a second-hand summary. 10 business days for this year's records, 30 calendar days for the 2 years before that, 15 calendar days once minutes are approved. Miss any of those, and the association owes up to $500 for that one denied request. Per request, not one flat number for the whole file, plus your attorney's fees. Texas gives 10 business days, with up to 15 more if the board gives you written notice of the delay. And here's a correction worth making out loud. I checked the actual remedies section of the Texas statute, and it does not set a $1 per day penalty for this. The real remedy is a court order compelling the records plus your attorney's fees. Nothing more, nothing less. Florida gives 10 business days no matter how you send the request, but how you send it decides whether you get paid. Certified mail, return receipt, and a late board owes $50 a day, $500 minimum. Email it instead, and you still get the records, you just don't get the money. Illinois currently runs 10 business days, and missing it counts as an automatic denial. Arizona gives 10 business days too. The review itself is free, and copies are capped at 15 cents a page. 3 more, and 1 genuine dispute. Virginia splits by who runs the building, not by condo versus HOA. 5 business days if a professional management company handles your association, 10 if the board self-manages. Nevada gives 21 days, and a missed deadline costs the board $25 a day. I'll say no cap identified rather than uncapped, because that's a statement about what the statute text I reviewed actually contains, not a promise there's no ceiling anywhere. Colorado is the one that's genuinely disputed, and both halves are true at once. The hard deadline is 30 calendar days. That part isn't in question. The statute itself also lists a $50 a day penalty starting the 11th business day. capped at $500 or your actual damages, whichever is greater. So if your real losses beat 500, the higher number applies, not the flat 500. Here's the dispute. Colorado's own state HOA office says it has no power to enforce that penalty. No jurisdiction to investigate, no authority to assess it on your behalf. Collecting it means suing your own association yourself. It does not mean filing a complaint with the state. And here's the fact that actually changes how you should read every number on this list. 5 of the 15 largest states we checked, New York, Pennsylvania, Ohio, Georgia, and Washington, have no numeric deadline in their statutes at all. Not a short one, none. The law in those states says something closer to a reasonable time or convenient business hours, and what that means in practice is whatever your board's own bylaws say it means, because the legislature never wrote a number down. If you live in one of those 5, a slow board isn't automatically breaking the law, which is exactly why the letter itself and what you put in it matters more there than anywhere else on this list. North Carolina gets its own minute because it isn't on either list. It's not a hard deadline, and it isn't no deadline either. The Planned Community Act sets no general deadline for a records request. What it does set are 2 narrow carve-outs, 10 business days for an unpaid assessment statement and 75 days for the annual financial statement, which the association has to send automatically without being asked. Outside those 2, there's a separate path, asking a court to order the inspection, and whether that path also gets your attorney's fees back is genuinely open. I could not confirm it either way in the statute text after 2 separate checks, so I'm not going to tell you it's settled. There's also a bill, House Bill 444, that would add a general 30-day deadline. It has not passed. Treat North Carolina as a state without a number today, not as a state where one is coming next month. Read your own CC&Rs before you rely on any number in this video. They can require more than your state does, never less. Laws change, and a few of these are close to it right now. If a lien or foreclosure is already on the table alongside this, that's a job for a licensed attorney in your state, not a video. Everything else here you can do yourself. Put the request in writing, cite the statute, give them a deadline.